please, Your Lordships. I appear in person with leave of the board. I understand that Matrix Chambers is assisting the board, and
yes, we are very grateful for the assistance given by the Mikey Curie.
yes, Mr. Hood is appearing for the respondent. My lords, I must first tender my apologies for the second bundle I sent. The attachments were not to correct, but my main bundle is the electronic one, which I'm given directives to follow that. The main bundle.
Yes.
Which runs up to page 606. 698.
698.
So I shall be referring to that bundle, basically, when addressing your lordships.
Let's just make sure that we're the one which runs
From page 1 to 698, my lords.
Yes, I've
What any MS numbers?
We haven't got the MS numbers on the hard copy bundles, but we've got a bundle which, we've got an electronic bundle which runs up to 606, I think.
And another one.
Maybe we've got a second.
698, my lords.
698.
Yes.
Well, the one that we have at the moment is 606.
Well, that from me, 698.
Well, with a bit of luck, we might not stray beyond 606. So.
Yes, I think
Let's just see whether we've got one on the central
Sure.
drive, which. So, does it have a title? When did you file this additional one?
That was way back 2 months ago, my lord.
Well, I'm afraid the one which is on our file has 606.
Yeah.
we don't have a printed version of it.
well, we don't. We have your bundle in printed version, volumes 1 and 2, but it doesn't actually have pagination. It has tabs.
Oh, that is the hard copies.
Yes.
Yes. Well,
Yes. Well, I tell you what.
Are you able to give us the tab references as well as the electronic ones?
Well, I will try to. my lord.
Yeah. Right. Let us see how we go. We've got a bundle which has 606, and we can try that out in a moment. Also.
Well, may I?
Yes.
Please proceed.
Well, my lords, central to this appeal is whether the judgment of the 5 bench judges is a correct interpretation of the rules of the Supreme Court. Now, the judgment itself, there are 2 pages, but then I'll refer your lordships to pages 300 to 304.
Right.
300 to 304.
And this is tab 9.
Tab 9, my lord.
Okay.
Well, may I, en passant, state to the board that this is not a question of relitigation or is a question of a collateral attack. I must express my thanks to the board inasmuch as when the judgment of myself against Bola was heard in Mauritius way back in 2010, and a judgment was handed out in July 2010, and I shall refer your lordship to that first, and that will be at pages 645, or your lordship do not have that one.
What's the title, Mr. Hurnam?
It's Hurnam against Ebola, and the reference is UKPC.
Hurnam Bowler, it's R20 in our authorities bundle in 2010.
That's right, my lords.
Yes.
If your lordship will bear with me on that.
MS page 564, according to this.
Presumably in a separate bundle of authorities.
Well, I shall invite the court to look at paragraph 40 of the judgment. Well, it runs from 35 onwards, 40, 41, and more precisely 41. But 35, in the course of his submissions, Mr. Hurnam referred to two statements by Bula for the reasons given by the Supreme Court in the judgment dated 18th May 2007, setting aside Mr. Hurnam's application for an order directing reopening of the criminal case against him. The board does not consider these statements of significance, and then refers to paragraph 10.
Yes.
Now, your lordships did, at paragraph 40 of the judgment, so there is no need to investigate the matter in more details, since it has been held this particular principle does not form part of the law of Mauritius, meaning the principle which is adopted in Chambre civile de la Cour de cassation.
Should we not?
Yes.
Should we not focus on the issue which is before us now? You received the clarification of that, at least on the 8th of June.
That's correct.
And
The issue is not related to the original litigation, but the issue is whether you're entitled to pursue any complaints you have about the original litigation in person in the Mauritian courts by commencing proceedings without an advocate and pursuing them. So that's the issue you've got to address us on, and you have a...
I certainly will, my lord. But then I said that this is not a real litigation, nor a attack to a collateral issue. But
No, I see.
If your lordship will...
I don't think you need worry about that,
Yeah.
because although that may be suggested at a later date, and you
Yes.
may have to deal with it at a later date, it's not what's before us today.
Well, what I said is because of the advice tendered and the judgment handed down at paragraph 41, I issued proceedings against the state
Yes.
and the respondent and the respondents. And this is 41. I said, no, can I read towards the middle of the paragraph 41?
Yes.
No equivalent amendment has been made to Mauritius. So the position remains that in the present proceedings, for example, the defendants could not introduce evidence of Mr. Hurnam's conviction as evidence that he has committed the offense of which he was convicted.
Yes.
That would be of some possible relevance in legitimate proceedings brought by Mr. Hurnam against Bola.
All right.
You're insisting on making the point that in due course
Yes.
you will have some viable claim.
Thank you.
But as I say, we're not deciding that either way.
We go straight to the point then, my lord.
Right.
And that is the judgment of the five bench judges.
Yes.
And as I said, it is up to 300, tab 9. Here we go. May I just lead through initially the speed at which they proceeded with this application? And it's a five-bench judge.
Right.
On Monday, 21st February, the applicant put in before the Honourable Senior Punitive Judge, sitting in chambers and dealing with inter alia procedural matters relating to a motion signed by himself, supported by an affidavit drawn up, as well as solemnly affirmed by himself. He also moved for leave to appear in person. So I need not read the rest. But then, at page 2 of the judgment, so the matter was called the next day, that is the following day. 21st February called before the judge, senior punitive judge, sitting in chambers. The matter was called the next day before a bench of 5 judges.
Yes.
So on that day, the case was called before the present bench. The court ascertained from the applicant that his motion for leave to appear in person contained 2 requests.
Yes.
The motion paper signed by himself be entertained, and that leave be given to him to conduct his case in person. Well, I responded to that, but then the court at the last paragraph of the page, one but last, the fact that the motion has been put in does not, in our view, preclude us from considering whether it can be entertained, having regard to the fact that it had been signed by the applicant himself without any recourse to the service of an attorney.
Right.
Accordingly, the prior judgment deals with only the second aspect. And the last paragraph, this is important so that as far as Code de Procedure Civile is concerned. Where there are rules made locally to govern procedure in our courts, those rules have to be followed, and reference to a different procedure which obtains in England under civil procedure rules or otherwise is not in point.
Right.
And they cite Section 8C of the Judicial and Legal Provisions Act, which I couriered separately at the request of the board, the whole bundle, because in preparing my bundle, I only referred to the relevant parts of the procedural rules which were applicable.
Right, we have that, yes.
Yes. So, my lords, I go on page 3. The rules of the Supreme Court were repealed, and the new rules, the Supreme Court rules 2000, are now incorporated in the third schedule to the Courts Act. The new rules do not contain provision which was found in Section 60. I will have to pose and submit extensively on this, Rule 60, and of course the judgment. Number one, Rule 60 had set a mechanism for a litigant to prosecute and a resisting defendant to resist an action. As it says, the Rule 60 or the previous Rule 1903, any party may make an application to the court by motion or to a judge. So it's a court by motion or to a judge, meaning a judge in chambers by way of praesife and affidavit, praying for leave to prosecute or defend a suit. So that, my lords, the distinction is the Rule 60 applied to both litigants.
Right.
Right? And of course, it either to the court or to the judge in chambers, which was independent of a main case. So you had to go first to the judge or to the court by way of motion and affidavit to seek leave to prosecute or seek leave to defend. But then...
Can you just help us as to where we actually
Yes.
find the rules?
Your Lordship has...
You said you couried them separately.
yes, that was a separate bundle.
It's
It was on
the second bundle, is it? Where is it?
it was on the desk. There's a separate little clip.
You mean the 2000 Act?
That's correct. Just the 2000 Act, my
Which
lords,
has
yes.
got
On the desk, is it?
which has got the rules behind it.
Jonathan. We had it before, maybe on the desk as well.
Yes,
No, I only had...
copied
Yes.
right this morning.
Well, have you got another copy? Because I'm not sure that...
My Lords, the Judicial and Legal Provisions Act 2000 is at R8, I think, MS 438.
Oh, that's helpful, thank you.
Well, I've just been handed all the bundles today by the respondent and amicus curiae persons appearing. But be that as it may,
Your Lordship
has been able to get there?
Right. Carry on then. Is that's the act which amended the rules?
The rules, yes.
But you said we had a bundle with the rules sequentially, and I've certainly seen it, but I'm not sure where it is. Is it in these documents or is it separate?
Well, I'm sorry, my Lord, this is where I said I did not feel the need to have it, the whole bundle put in view of its size, but of course at the request of...
All right, well, what have we got which contains the rules?
My Lords, again,
It's
if it helps...
R2, is it?
R2 is the 2000 rules, yes.
Well, it must have been that I was looking at, yes, thank you. Right, carry on, you were going through this
Yes.
judgment of the full bench.
Yes, if Your Lordship would please bear with me, so that the application must be made to the court of the judge on sufficient cause shown to its or his satisfaction by such party, may make order that such a party may sue or defend, as the case may be, in such court, in person, without the assistance of an attorney, subject to such conditions as the said court or judge may think it fit in each particular case. So that that was the law previously.
Right.
So when the court, the 5 bench judges rule on this matter. They say this: the provisions which are contained in that rule have been clearly repealed.
Yes.
The rule form part of the repealed Supreme Court rules. And the provisions in question have not been reproduced in the Supreme Court Rules 2000. As a result, because this is not reproduced, the situation of proceedings before this court, as well as institutions of proceedings before a judge in chambers, now requires recourse to an attorney. This is what they come to state as the result of the change in the law. But they never said a word about the defendant or the resisting litigant.
Well, that's because they take the view that there is no longer a restriction in respect of defendants, which one understands because defendants have been dragged or are dragged before the court willy-nilly.
Yes.
But although they put the court, or perhaps the cart before the horse, the reasoning which follows indicates that they take the view that other rules do impose a restriction in respect of claimants.
Yes, but then, yes.
So they've stated the conclusion first, but they go on to give you the reasons in a moment, don't they?
Yes, but yes, they're going to say simply regarding the plaintiff or the prosecuting litigant.
Yes.
But what I'm saying is the new Supreme Court rules has liberalized access to the Supreme Court. That is in terms of both the plaintiff and the defendant.
That's your submission.
That is my submission.
They are taking a different view because they say that all they've done is remove a provision which had effects beyond claimants, it had effects on defendants. You still have to construe the rest of the rules to see what the position relating claimants and no doubt defendants is, but there's nothing on defendants, so they can, on the face of it, appear by themselves, but claimants, there is something.
Yes, but you would see the last line of that page 3. The requirement in Rule 3.3 that every plaintiff with summons shall be endorsed with the full name, office address, and stamp of the plaintiff's attorney is, in our view, designed to ensure that all actions in the Supreme Court are normally entered via an attorney.
Yes.
The very fact that Rule 3, this existed in 1903. This rule existed in 1903. Yeah. You have to have the rule, you have the stamp of the attorney.
So your argument is that 3.3 was there before.
Yes.
The repeal of Rule 60, in fact, widens the scope for litigants in person rather than narrows it.
That is correct, my lord.
Got it. Right.
But having,
next.
Sorry. Having already, if you wouldn't assume for 1 second, Mauritius, a developing nation, in jurisprudence equally, would not go backward on a matter which was open to all litigants in Rule 60, having repealed it, this rule.
But it wasn't, yeah.
Having repealed this rule, there is no mechanism set by this judgment even how someone should proceed regarding what is called specific exceptional circumstances. Your Lordship will note at the next paragraph. However, as rules of Supreme Court are made by the Chief Justice of this court to promote the smooth and proper administration of justice, this court retains, in our view, a residual discretion upon good cause shown. Exactly what was sufficient cause shown to allow a litigant to dispense with the services of an attorney and sue in person. Then they go on to say, hence the provision in Rule 3 of the legal fees and cost rules incorporated in the 4th schedule to the courts for payment of relevant fees by the attorney of the party concerned or when no attorney is employed by the party. They seem to suggest, and I say this is where they went wrong, that because the rules have changed, they have been repealed, and because Rule 3 says what it used to say before, they say now every litigant who wishes to dispense with the service of an attorney must necessarily come through an attorney.
Yes. I mean, your case then is, it's rather curious that the repeal of Rule 60 should have made it opened greater possibilities to defendants to act in person,
but reduce the possibilities on the face of it for claimants to do so.
This could not be engaged at all. That is why I say Rule 3 Rule 3 of the fourth schedule is designed to protect both the litigants in person and the defendant in person. Would your lordship proceed to...
Look at that then. That's the one about costs, is it?
That's right.
Where do we find it?
That's in the fourth schedule of the Act.
Yes, I know, but tell us where the fourth schedule is in the
It's towards the end.
authorities. Have we got it in the bundle?
It is in the same bundle, my lord.
Scheduled to the 2000 Act. It's the fourth
Schedule
schedule.
4. That should be Schedule 4, the fourth schedule, my lords.
Rule 3 of the fourth
Rule
schedule.
3 of the fourth schedule.
To the 2000 Act.
That's correct.
Well, where's the 2000 Act? You've got it separately, haven't you?
I think Mr. Casey said it was in his bundle.
My lords, yes, it's R8.
R8.
And I think the fourth schedule is MS 464.
Where's the section? Is section 198? We don't have.
Which one, my lord?
The fourth schedule is made under section 198, but we don't have that.
198.
I think
Oh,
we
we do.
do, we
Yes, we
do
do.
have that
Yes, no, we do.
because
444.
this is section 198
Eight.
inserted in 2000 into the Courts Act. Is that right, Mr.
That's
Hurnam?
correct.
Yes, page 441. Yeah.
So it forms part of the Act. It is the schedule to the Schedule 4 to the Supreme Court rules. It forms part of the Principal Act. So that the legislators seem not to discriminate between a prosecuting litigant and a defending litigant.
Mr. Hurnam, looking at it more broadly,
Yes.
what's wrong in your submission with a residual discretion upon good cause shown to allow a litigant to appear in person?
There is no mechanism set by the court as it used to be in Rule 60. Having repealed it, the inbuilt residual discretion or inherent discretion remains all throughout, and it cannot coexist with an express statutory provision. The express statutory provision being the Rule 3 of the fourth schedule. How could initial...
No, wait a minute.
Yes.
Rule 3 of the fourth schedule
That's right.
makes perfectly good sense in relation to defendants who act in person, or in relation to claimants
Yes.
where permission is given to act in person. But I appreciate you say
It doesn't say
that
permission.
there isn't any mechanism for the latter, but it certainly makes good sense in respect to the former.
But does it... well, my lord, it would have said. It would have said so, that if leave is obtained, then of course this will trigger the Rule 3 of the fourth schedule. If your lordship will look at page 129 of the bundle of my brief, electronic brief 129, it is in that perspective 129. It's 126 of the hard copy. Well,
What are you looking at, Mr. Hurnam?
the draft rule
A draft.
What tab is
at
this?
129. Oh, yes, sorry.
Well, it's certainly not 129 on the electronic bundle.
126.
126.
That's right, it's 126, but if your lordship will look at that,
I don't have this pagination, Mr. Hurnam.
sorry, my lord,
I don't have this pagination. What document are you looking at? Then we can locate it.
it's the draft rules, which was brought in. Draft rules,
Is
yes.
that tab 2?
No.
No, my lords. Is it 126 of
It is 126.
It's 126
The electronic bundle, but
electronic bundle.
the problem is that the hard copies don't have the
File
electronic bundle
volume.
pagination.
Volume 1, tab 2.
Thank you.
Draft legal fees and cost rule.
That's right.
2011.
This is
Mr. Hurnam, wait. Are we in the right place? Draft rules number
That's right,
2.
you are.
Thank you.
We all are. This was following the judgment which they had handed down, and you can see under heading 4th schedule 2 payment, they come to bring what I had submitted eventually. There shall be paid by the attorney of the party concerned. So it changes the whole system. Or by the defending litigant, as the case may be. Would your lordships now follow the reasoning? So if it was proper for them to use the inherent jurisdiction to grant leave to prosecute, why these draft rules brought in after the judgment to say there shall be paid by the attorney of the party concerned, as opposed to what rule says, by the attorney of the party concerned, or when no attorney is employed, by the party.
Just help me. Have these rules ever come into force?
Well, I am not sure. Not until today.
It didn't apply at the time that you were dealing.
Well, it came.
That may not matter.
It came in 2011, my lord, after the judgment.
Well, they're draft.
Yes.
Have they ever been promulgated?
Well, it came in 2000. It was brought in as a draft rule. It was circulated to all the persons involved in it, and this is how I obtained it.
But it may just have been intended to clarify. I mean, I think it's the fact that they did it after the judgment, consistently with the judgment, may or may not throw light on what the previous position was. It may have just been clarificatory.
But in any event, if you compare the new draft Rule 2, headed payment,
Yes.
you can make the same point, I think, on Rule 3 of the 4th schedule, which we have at MS 464R8 in the respondent's volume, because that too speaks about the attorney of the relevant party paying the fees, or if none.
Yes. But then if this is so,
Party.
yes, if this is understood to be that in the exercise of the inherent jurisdiction, the court could apply the Schedule 3, Schedule 4.3 of the rules, there was no need to bring come up with this amendment.
Well, people sometimes do things to put matters beyond doubt, and I think it's a rather small straw that you're clutching at on this point.
Well, my lord, as I said, that being so, I feel that if they were right in the interpretation of the rules as they did with the 5-bench judgment,
Yes.
they would not have come up with this one. That is my position on that. They wouldn't have come with a proposed amendment.
Well, sorry, I think it's difficult for you to suggest that these are made by the Chief Justice. To treat them as an acknowledgement that their judgment was wrong is certainly pushing
But why did they not proceed any further with that?
matters. Anyway, right, carry on.
Why did they not proceed any further with that? But, my lords, what happens to the defendant? What happens to the defendant as a matter of course? In Rule 3 of the Supreme Court rules, as I said, I will adopt my submissions as set out in my hard copy part 1 of my skeleton arguments, wherein I have set out the relevant rules individually, but relevant to the matter at hand. How would someone read the rule, my lords? Say, as far as the plaintiff goes, he must present an attorney, serve the documents on the defendant, and the Rule 3 says the defendant may appear or be represented. So there is already room for defendant to appear or he be represented.
So this is Rule 3.
Rule 3.
Right, yes. Well, I think it's accepted that the position relating to defendants is different.
Yes, but it was not different with Rule 60. They were in the same position. Would the rules become discriminatory towards the parties? That is my point.
Well, you've made that point.
This is what I say.
We understand it.
Would it be discriminatory towards two litigants?
Yes, you don't need to say it again, Mr. Hurnam. We've got it.
Thank you. Now, why I'm saying that is because they wanted to bring uniformity between proceedings at the Supreme Court and proceedings before the district courts. And this is set out in the case of Tatara. This is I've just been handed away, but I had it in my bundle, my lords. The case of Tatara is one of my own cases.
How do you spell the name again?
I shall.
Tatara against Yuglal.
That's right, Lord.
That in your bundle is number 7, volume 1.
Yes.
Yes.
That is correct, my lord.
Was that a slightly different situation, Mr. Hurnam, where you were, of course, counsel, and you were seeking to appear without being supported by an attorney? Wasn't that the point here?
No, it was a case where a defendant litigant had not retained the service of an attorney, but he had retained my services to appear for him before the district court. And what happened was he had signed his demand of particulars. I couldn't sign it. He had signed it. And when the matter came before the court, district court, it was referred to the Supreme Court by way of case stated. An opinion was sought, as it says at it's page 293 of the electronic bundle. It says this.
Oh, we don't have that pagination, Mr. Hurnam.
Yes, but your lordship has been able to get there.
Which page? Page 2 or?
293.
We don't have that pagination, Mr. Hurnam.
Oh, my lord.
It is.
I've got
Well, there are only 2 pages to this, so is it page 1 or page 2?
Oh, of the judgment?
Of the judgment.
Oh, yes, there are 3 pages only of this.
Well, okay.
Yes.
2.5.
Yeah, but page 293 is some document, one of your submissions, I think.
What does the paragraph that you want us to look at begin with, Mr. Hurnam? Which
Well,
word?
this matter came before this court by way of a case stated for our opinion under Section 126 of the Courts Act.
Yes, first paragraph. Thank you.
The plaintiff had sued the defendant before the District Court of Mocha to claim damages. The defendant appeared and produced a letter from Mr. Hurnam, to which was attached a demand of particulars signed by the defendant. When it was observed to Mr. Hurnam that he should be instructed by an attorney, counsel submitted that a party to a civil suit is free to sign his pleadings. In such a case, the party can be represented by a barrister without being instructed by an attorney. That was the motion. That was the case stated, which went for the opinion of the Supreme Court. And of course, your lordship will note at the next page, the one but last paragraph. We have noted that in framing his second proposition to the lower court, Mr. Hurnam sued the phrase in such a case so as to link it to the first proposition. In other words, says counsel, if party is allowed to sign his pleadings and he does so, then the question of retaining a solicitor should not arise. This ignores the fact that at any stage of the trial, the need to review, strike out, or amend pleadings may arise. Besides, there is no magic in written pleadings in a district court. And then he says, a defendant to a suit can plead orally if he is not represented. No doubt he can ask a friend to frame his answer to a plaintiff for him in writing. And proposition will be the same. The point that counsel is not authorized to bind his client on a matter of pleading at any stage of the trial. So either the defendant appears on his own and pleads orally or in writing, or he is represented by counsel instead of an attorney. So they reach the position that for the above reasons we hold that in answer to the case stated that in a district court
So the position is that
Yes, the position is in the district court.
In the district court, a defendant can appear on his own.
No, it's number one. A party to a civil suit is free to sign his pleadings if he is unrepresented. A party, meaning a party who is the plaintiff or the defendant.
Oh, I see.
That's what the point is about, my lord.
Right.
And therefore, if this is, they wanted to harmonize this with the Supreme Court.
Where do you get the proposition that anybody wanted to make the Supreme Court the same?
Well,
as
when they repealed Rule 60,
But why does it follow that that was designed to make the Supreme Court the same as the district court?
well, my lord, the very fact that a defendant had to seek permission to appear, to be represented, to apply for leave to appear in person, this is no longer the case. Now, just because the district court allows this, it must be at par with the Supreme Court rules,
Right.
because they relate to pleadings. But the basic proposition is this, my lords. An attorney is a modate ad litem. He binds his client, the attorney. If the attorney can bind the pleadings, why can't the principal can bind the pleadings? The parties, meaning the plaintiff or the defendant. So that, as I say, having liberalized access to court, they wanted to uniformize. This is in 1986, my lords. I've been trying to do, 1987, this matter came before the courts. And therefore, it is in view of that change that they repealed the law. Why did they repeal the law? Why could they have repealed that mechanism for any party to apply for leave on good cause shown? The new regime does not show that, my lord, any mechanism. So how do we proceed?
I don't understand this case, Tatteraj and Juglao, because the answers given on the third page don't seem to be consistent with the reasoning on the first page. The reasoning on the first page in the second paragraph seems to say that in civil matters...
No, that was my proposition.
that you need, well, perhaps it doesn't say that, it's only dealing with whether counsel has been instructed by an attorney.
That's right.
If counsel appears, he has to have an attorney.
Yeah.
And can't bind his client without.
Yes, I see. So the answer on page 3 is given without any particular reasoning, is it? It's just, is there any reasoning to support the first point? It's in your favour, clearly.
Yes. Well, I say a party to a civil suit is free to sign his...
But it doesn't seem to bear on the issue which was argued. The issue which was argued was whether a barrister can appear without having been instructed by an attorney.
But the
answer... first point which they assert, which doesn't seem to be supported by any reasoning, is that a party to a civil suit is free to sign his pleadings if he's unrepresented.
But yes.
Where's the reasoning in support of that? And was Rule 60 in existence at that time?
If at all, no, say, yes, my lord, Rule 60.
It was.
Rule 60 was, it came in 2000.
Consistent with Rule 60 then?
Yes. In 2000, the rule was repealed.
Yes. So it was in existence in 1987.
Yes.
Well, the first proposition, if it applies to claimants as opposed to defendants, which presumably it does since we're talking about a claim here.
Well, yes. But a party to a civil...
Wait a minute, we're talking about a defendant.
Yes, it's a defendant.
Yes. So maybe the first proposition only applies to defendants. Because otherwise it's inconsistent with Rule 60.
But Rule 60 applies in the Supreme Court only, my lord.
Yeah.
Oh, I see.
This is what I say. Rule 60...
Different rules in different courts, aren't there, Mr.
That's right. That's
You
right.
can see that from the end of the judgment in Tattara.
Yes.
Which mentions also the intermediate court.
That's right. But they're the same. The intermediate court...
Where the rules about representation look as if they're slightly different. That happens.
This doesn't help us then very much.
Yeah.
I mean, it seems to be dealing with a different court, it's dealing with a defendant, not a claimant, but the main point is a different court with different rules.
Well, I'm suggesting that by repealing Rule 60,
Yes.
they wanted to, the Supreme Court decided to uniformity of procedure in all the courts. That is my proposition, my lord.
Right, I see. So, achieving Rule 60, intention was harmonisation, yeah,
Yes.
on the lines of this case.
So, my lord, it was coming back to the judgment of the court, of the Supreme Court, on the rule, on Rule 3. This is in my skeleton argument, Part 1, and it's, as I said, questions were submitted to the board. Whether a litigant in person is entitled to issue process in the Supreme Court without any service of an attorney, pursuant to Rule 3.3 of the third schedule to the provisions. The Supreme Court rules incorporate the Supreme Court in the third schedule to the Act. And the question whether the requirement in Rule 3.3 that every plaintiff summoned shall be endorsed with the full name, office, address, and stamp of the plaintiff's attorney is, in our view, designed to ensure all actions in the Supreme Court are normally entered via an attorney, and accordingly extend to other modes of entering actions, notably motions, as decided, mirrors a correct interpretation of the rules of the Supreme Court.
Which
I'm looking at
page of your
it's page 2 of my skeleton argument,
right.
Part 1.
Okay, yes,
Your Lordship have seen that?
yes,
The question submitted is question 2.
yes.
Yep.
Yeah,
And
we've
then
got
question
that,
3, which is submitted for your Lordships, whether on a proper consideration of Rule 3 of the 4th schedule of the Judicial Provisions Act, incorporated in the Act, it is open to a prosecuting litigant and a resident litigant to dispense with the service of the attorney, of an attorney from entering any action before the Supreme Court, and therefore the judgment of the 5-bench court is plainly wrong to the effect that all actions in the Supreme Court are normally entered via an attorney, and accordingly extends to other modes of entering actions, notably motions. Well, it is still my submission that since there is no mechanism for moving for leave to appear, either for the defendant and attorney anymore, other than Rule 60, which will repeal, we must have, I pray in aid, Rule 3 of the 4th schedule.
That's the cost rule.
Well, it lists, yes, but then
Got it.
a party can pay the cost or the attorney can pay the cost.
Yeah.
If there's no attorney retained, either word.
Right, we've had the cost rule. It's
Yes.
might be said against you, it's slightly a tail wagging the dog. It's a long way down costs. But leave that aside.
But they really, but they relate to, if your Lordship will see, at the same, I have reproduced the rules, and my arguments are, the rules are they are at page 10 and onwards, my Lord. But I rather go at page 9 first of that bundle, hard copy,
Of your...
of my skeleton argument.
Yes, right, I've got that, yes.
Yes. Rule 3A, I need not go there. State the names, occupational addresses of the parties, state the substance of cause of action, call upon the defendant and other party to appear before the court on a date and time specified in the summons, hereinafter referred as returnable date, and then be accompanied by a notice, etc., etc. Because Rule 3.3 says, every plaintiff with summons shall be endorsed with the full name, office, address, and stamp of the plaintiff's attorney, which shall be the elected domicile plaintiff. The court says, because of this, all proceedings should go through that via an attorney. But what difference does it make, my lords, when a litigant in person issues the process, has his name and address inserted in the summons for a reasonable date, and go through him? If the attorney can bind pleadings, the plaintiff can do that, or the parties can do that equally. And then your Lordship will see that in the judgment. Because this is said that it must bear the name of the attorney and his office address, and he has sort of elected domicile, that should be the venue which should be adopted. But then as page 10, my lords, I have stated, and I'm not at the risk of repeating, there shall be paid to the conciliated fund by the attorney of the party concerned, or when no attorney is employed by the party, the fee specified in Part A of the schedule.
Yeah.
I pray in 861 of the Interpretation of General Clauses Act, 1924, that the schedule and the appendices of the enactment shall form part of the enactment.
Yes.
So that, as I said again, if your lordship will follow at page 11, the right to access to courts in Mauritius are regulated by rules of the Supreme Court. Constitutional rules, the Supreme Court rules, the Supreme Court preparation briefs, the industrial court rules, and the intermediate court rules, and a few others which are not. And also, since we were a French colony, we have inherited the hybrid procedural system in relation to civil matters, commonly referred to Code de procédure civile. And I explained that the rules of court are made by the Chief Justice pursuant to 198 of the Courts Act.
Can I just ask, I mean, is that relevant background that there is a distinction, a general distinction between common law countries and civil law countries? In many civil law countries, including France, the use of a lawyer to pursue proceedings is required.
Yes, but in France they have changed now, my lords. Litigants can do that.
Well, maybe, but the Mauritian procedure is qualified in the sense that the court has said that there is a power, a discretion to allow a litigant in person, so there's a certain flexibility.
Where is that?
But the starting point, is the starting point surprising in a country which has modelled its civil law, and you tell us the procedure included to some extent on French civil law?
But they are not applicable.
No.
And so far procedures are concerned, if we just refer to the judgment of the full bench, we just gone through, your lordship will say that Section 8 of the Act, the main Act, precludes. Because they are statutory rules which obtain precedence over CPO rules.
Section 8 of the Courts Act or the Judicial?
Yes, the 15 of the Court, yes.
Okay, the Judicial, right.
Yes, the Legal Provisions Act.
Code Napoleon amended, yes, I see.
You see I started by saying that, my lord.
Well, is it Section 8 or Section 7 which are...
Section 8.
Section 8 is repeals and consequential amendments. Section 7 is Code Napoleon amended.
No, it's... It just...
Yeah, Article 1341 no less.
Your basic point is that we're concerned with statutory rules which replace any French procedure. But there is some French procedural background in the Code of Civil Procedure, Code Civil de Procédure in Mauritius.
That's right, man. There are some still available. They have not been...
but not on this subject.
Yeah, but not on this matter.
Yes.
On this matter of procedure, it's altogether our own procedural laws which have been enacted. We cannot go outside that. That is set out very, very succinctly by the Supreme Court itself. But my lords...
What I'm really saying is that as a matter of, or suggesting, is that as a matter of cultural background, it's perhaps not so surprising if the idea still prevails that in prima facie, litigants should be represented when issuing proceedings by a lawyer.
That is correct. It is, in the majority of the cases, litigants are represented by attorney and counsel in Mauritius even. I am the only one. But your lordship will note from my skeleton argument at page 21 the series of cases which I issued way back from 1995 onwards, these have been listed. But how could it be that it was simply by way of, they cannot sort of say, this was a matter as a result of oversight. A list of cases which appear at page 21 of my skeleton argument, 22, 27, 23. All these, your lordships have that page 21.
Mr. Hurnam, since 1995,
95.
forgive me, since 1995, how many civil actions have you issued in Mauritius, and have you issued them all in person?
All in person.
How many, first of all, let's get how many?
It's about eight.
You've only issued 8 actions?
9 actions.
Only 9 actions since 1995?
Yes.
I see. And you've issued them all in person?
All in person. And these are set out, my lord. And especially...
And how many of them have now been refused? All of them on the grounds that they were...
No, they were not refused. They went through. No objection was taken.
So you're not including the present case?
Except the present one now.
I see. Well, and the full court one as well.
They said, now, the only one they took objection is the present one. Otherwise, all the actions...
The full court is a different a different action, isn't it?
Yes, it is different
Yes,
action.
so they've taken objection in that one and in this one.
Only in this one.
Well, and in the full court one, because it was decided against you.
Well, my lord, in none of... your lordships have page 21?
Yeah, it may not matter anyway. We've got the picture that you were allowed for a period to
all of them
pursue proceedings, and they were decided against you or for you on other grounds.
No.
What's happened to
On
that?
other grounds.
No. I have set out, if your lordship will follow me, there was an action against the contract chief justice at page 21, line 20, against the Attorney General in the presence of Chief Justice.
Yes.
I moved to have the contract appointment rescinded, and prior to the hearing and before expiry the contract, of the contract period, the contract chief justice resigned.
Right.
I said, as I said at line 10 of page 21, in answer to A. Supra, the appellant brings to notice of their lordships that on occasion arising, in order to protect the integrity of the judicial process, he has unhesitatingly initiated some of the following proceedings, amongst others, litigate in person with no objection from the parties, or even from the court.
All right. I think the position is that the court acknowledged that this had happened,
yes,
and it said that henceforth it mustn't be permitted.
Yes.
I think you have a point on the word henceforth.
Henceforth I will have to
You
come
must be
to
a bit conscious at the time because
I will.
indented
But
for a limited time. But
on the
you've
henceforth,
got an argument on henceforth, and you've got an argument on the difference between plaints and motions, as I understand it. And you need to develop all these.
that is correct, my lord. But if your lordship will take, if I can take your lordships to page 22.
Don't have pagination, Mr. Hurnam.
Item is 216.
Yes,
Sorry, page 22 of the skeleton argument.
It's
my lord.
skeleton.
22 of your skeleton argument.
Skeleton arguments, yes.
What's it? What is it? 216.
Yes.
Yeah.
Well, my lord, at item 6,
Yeah.
item 6, I issued contempt proceedings against the Chief Justice. He acquiesced service. He came and defended the action with no objection from either part.
We've got that point, that for a time the Mauritian courts took a different attitude.
But the problem now arises, and this has never been answered by the party. If your lordship will look at item 7 on that same page, item 8 on the same page, and item 9 on the same page.
Yep.
And if we can, if your lordship can proceed to where I was at 304, 300, sorry. Well, I'm sorry about the pagination, but 305 to 313.
What's the internal number?
24, isn't it?
305 to 313.
24 of your printed case.
It's the proceeding, yes, sorry, my lord. I have attached this is the crux of the matter. Whether the judge and party, how can they decide
If we're now going to 24, can I just ask you about 23?
Yes, my
You
lord.
put in all this stuff about vexatious proceedings. Speaking for myself, I didn't quite know the relevance of it unless you have been declared to have conducted vexatious proceedings.
Not yet.
You haven't.
They have brought
Right.
in changes which have mounted a challenge on that as being ad hominem law. But that is not.
I see.
That is
then,
still pending.
Page 24 then. Very well.
What is important is at least 4 of the judges who sat on the bench to hand out their judgment had proceedings issued by me against them. And these proceedings were still pending. Before, and I asked them for a challenge, they didn't recuse themselves. They continued.
Yeah.
And this is the crux of the matter, my lord, in this.
Well, no, it isn't, you see. The crux of the matter is whether you can do it in person or not.
But, my lord, I mean, how would the judges against whom actions have been initiated in person before the intermediate court, now they're on appeal before the Supreme Court, they would decide whether a litigant in person can sue or not?
Yes. Well, I think it's not a direct point. You're before a court against which that point doesn't apply, and we're deciding the issue.
Oh, you mean sorry, Mel,
We're deciding the issue, is the point I'm putting. So you're able to argue the issue now. Your point is that it was decided previously by judges who may have had an interest, but that doesn't apply here.
It doesn't, my lord. Your lordships have seen the proceedings, which are still pending?
No. We want to hear your arguments on the point which arises here, namely whether a litigant in Mauritius is entitled to pursue, under the rules, proceedings without a lawyer.
Well, the next issue I'll have to proceed to, my lord, is, and I'm citing here, the principle whereby a civil claim must be capable of being submitted to a judge ranks as one of the universally recognized principles of law. Same is true of principle of international law. As the case of Gold against United Kingdom, I understand that one of the...
Which case?
Golder, G-O-L-D-E-R.
Golder.
That's right. Against the United Kingdom, ECHR 21 February 75. That is my basic proposition, that in a civil matter, a civil claim must be capable of being submitted to a judge. And it ranks as one of the universally recognized fundamental principles of law.
It is, the argument against you is that it is capable of being submitted to a judge. Do we have Golder?
I understand that the other party I've got it from them. Yes, my lord, they have. Yes.
It's not in the amicus bundle.
No, it isn't.
No, it's not an bundle. It's the respondents bundle, which I referred to, and I cited it.
Well, the amici curiae have helpfully referred to some, I think, European Court of Human Rights case law on this point. I think I'm right in saying that.
Yeah, but be that as it may, my lord, be that as it may, there are 2 other points which...
Yes.
Am I right?
Yes.
Which
is number
paragraph?
5 in Ms. McColgan's.
Yes, paragraph 20 of their... you've seen the amici curiae submissions.
Yes, yes.
Paragraph 20, as my lord refers to GL and SL against France, which is their tab 5, the amici curiae tab 5.
Well, I say that's a basic principle.
Well, certainly it is a basic principle, but it's not infringed by a requirement that you use a lawyer.
Yeah, but that is a different issue, my lord. That is member state, and we are here. You are the highest jurisdiction of our republic. Yeah. That is a member state. Can have limitation insofar as certain matters are concerned procedurally. Yeah. A member state. But we are not member state. We are at the highest jurisdiction, Mauritian.
Yes.
And therefore, the margin of appreciation doesn't apply.
That's correct.
What?
On the other hand, you might bear in mind that this court generally leaves the interpretation of local procedural rules to the local courts, because they're very much the people who operate the rules, and we tend not to get involved in that sort of issue.
I have had previous directions from the board on that issue, but when it comes to a matter of constitutional importance, the board has always intervened.
Well, you haven't pursued a constitutional claim. I think it's the first time you.
Well, I have, my lord, in my submissions.
No, I meant you haven't pursued it below, and you just now mentioned it here. It is perhaps touched on in your skeleton before us, as has been pointed out by the first respondent and by the amici curiae. But I think you must. The position is you didn't pursue it below, did you? We read the submissions and
before that court.
Yes.
No, I didn't take that point before the court. I took it in my application for special leave, and I said that this board is not inhibited from grappling with the problem, because it is a matter of constitutional redress.
Yes. Well, can I just make the position clear? Normally, I think, as you were warned by previous refusals of permission to appeal, normally, again, that is a sort of point that this court will not entertain for the first time before it, because it values the contribution which the local courts make. So we may be prepared to hear your argument, but it'll be without admitting the point at this stage. In other words, we'll hear it de beniesse if you have a constitutional point, but you mustn't take it that we're necessarily going to decide it, because we don't normally decide that sort of point without the benefit of the assistance given by the local courts.
Well, I suppose, my lord, that the right to the protection of the law and due process is governed by that, principally. Well, if a litigant in his own country is not provided the protection of the law and due process, well, we are at a disadvantage. But this matter was never raised at the court at all.
Well, that's your problem. Normally, if you've got a constitutional complaint, the place to raise it is in the local courts, and then take it up the legal system, but you haven't done that.
Well, the next issue will be, my lord, two issues: whether the rules of the Supreme Court are mandatory or they directory. I need not go into the various matters raised and submitted to your lordship in answer to the respondents' statement of facts, where I have set out that it is for the court to interpret whether they are mandatory or they are directory. And the authorities on this point that on a proper interpretation of the rules, the courts decide in order not to defeat the ends of justice, but to meet justice, to be directory. Well, the earliest authority I have, and it was way back in, I don't know, I have got a very, not a copy in the additional brief, in reply to the respondent's statement of case, my lords. It will annex XB. Your lordship have a copy of that?
XB?
XB is a case of Kesnell and others against Dorel, 1867.
1867?
That's correct, my lord.
So where do we find this?
In that...
Well, it came...
Yes.
Reply is the reply. Thank you, yes.
Yeah.
My lord, this was a matter of procedure, if your lordship will bear with me. I simply wish to refer your lordship to paragraph 1, 2, 3, the fourth paragraph of that first page. Your lordship have found it?
Now, which tab was it?
Well, Annex XB.
D.
B for brother.
Right, B brother.
I have it, yep.
It would really be a misfortune to this country if, way back in 1867, if the law stood thus, that for a formal and technical omission or pure procedure, parties could lose forever and without a remedy real and substantial rights, that such is not the law, and we hasten to say. And at the next page, if you turn over, first paragraph, the judges who have framed those rules retain in their application a certain amount of discretion. They are to be enforced in all cases, but they are to be enforced so as to further, not to defeat the ends of substantial justice. Non-compliance with the provisions ought to be visited by some penalty, but where such non-compliance does not affect the substantial merits of a case, and where the court is satisfied, not on mere statements of the parties, but on proper evidence that the strict application of a rule in a matter of form would work irremediable injury to one of the parties, it lies with the court to modify the application under the penalty of cost, and this in the way which would appear to be more conducive to the ends of justice.
Well, this is a ringing endorsement of the court's discretion to do justice
on the rules,
despite the rules.
Yes.
And how do you apply it?
Well, they say, as a matter of fact, because there has been change in the law, the other Rule 6 has been repealed, because there must be the address of the attorney, the rules must be applied with rigor.
Well, they don't say that. They say that in the present case, if you could show some good reason why you needed to be represented by an attorney, then the discretion would be exercised in your favor. But
yes.
you haven't either below or at any stage shown anything of that nature.
But, my lord, the mechanism itself is no longer applicable. On what basis do I do that?
The full court expressly said
yes.
that it exists. You're saying, are you, that they're wrong in that respect?
What?
That if they're right about the requirement to have a lawyer, they're wrong about the discretion. Is that what you're saying?
What I'm saying is, following the change in the law, whatever discretion they have, they still have it inbuilt in them. They can't refer to the Schedule 3 and Schedule 4 of the third, Rule 4, Rule 3 of the fourth schedule to bring in this issue of discretion. That's what I'm saying.
No, but you've referred us to this case, which says that the judges who frame these rules retain in their application a certain amount of discretion. On one view, that's what the full court said. You have a rule, but the sanction is open, and they have a discretion to allow a litigant, if appropriate, if necessary, to appear in person. But it's for you to establish that that discretion ought to be exercised, and your case has always been you have a right, and you haven't, therefore, felt it necessary to try and show some reason why the discretion should be exercised.
But, my lord, the fact of the matter remains that this judgment came post all applications. I mean, there was no element of any exceptional cause to be shown. The court had invited me to give evidence of any exceptional cause before proceeding to set aside the application. But they did not do that, even if they were minded to exercise their discretion. On what basis do I do that? They allowed me all the time to issue process against them. How would I, in the middle of a case which I've started after the judgment, they must ask me. In this case, in the present application, I asked to give evidence on special circumstances. They didn't even look at it.
Show us about that. What evidence were you going to give?
What evidence I was going to give? But
what were the exceptional circumstances? Where I want to see where you
I asked them to
indicated what they were.
No, I said, allow me to give evidence on special circumstances.
Well,
because these cases already entered, they're ongoing cases, my lord. These cases have been started well before the ruling.
The normal way of giving evidence would be to file an affidavit, presumably at the commencement of the proceedings. And if you were on notice that this issue was hanging over you, to file an affidavit at that stage, if you hadn't done so already. So you didn't do that.
My lords, you would note that this motion was made on the 30th of November 2011, May 2011, the present application. Yep. 30th of May 2011. I shall come to that. But the judgment was handed down the 1st of July 2011. So in the course of the hearing process, before the court, Supreme Court, Mr. Justice Doma and Mrs. Tilak.
Yes.
I asked, can I give evidence? We can give viva voce evidence before the court. They simply refused to.
Well, the issue in this appeal is whether you have a right, it's not an issue whether or not the court wrongly refused you the opportunity to invite them to exercise their discretion. I think we really ought to concentrate on the issue that is before this board.
Precisely, my lord.
Yes.
But,
Do that then.
as I said to your lordships, that this matter came well before.
Yes.
The judgment was handed down.
Right.
Well, the judgment was handed down. In the course of the proceedings below, I did ask the court to allow me to.
Yes, well, I think we have that, yes.
Yes, but having not given me that opportunity,
Yes, well, I think we have that as well. I think.
they simply strike out. And especially one of the cases referred here already says in so many words that my claim will lapse. That is, there is a limitation of action of 10 years.
Yes.
The one in which your lordship have reserved the issue. So, then I'm left without any remedy at all. The case, I'll get the relevant. My lord, that's page 155, 154 and 155, where the order of the Privy Council was made. The order was made.
155 of which, please?
Of the order was made by the Privy Council, granting leave. Your Lordship will see, it is ordered that permission be granted in proceedings, these present proceedings. The proceedings in 2016, 0038, 039, 0040 be stayed until further ordered. Now, the proceedings in 0038 has already, the limitation of action has already happened. Shall be without any remedy. And in that matter, the case of Arangi.
Sorry, I'm not
Sorry.
with you as to where you're looking at for the court.
Well, my lord, if your lordship will see
Is it
the order.
155? Is it?
155.
155.
That's right.
In electronic version?
That's right.
And that's your
Yes.
That's notice of appeal.
notice of appeal in the electronic?
Yes.
Maybe it's after that, is it?
It is ordered by the. That was way back in.
This is the order of the 25th of May,
25th of May, my lord. Yes,
2016,
that's correct.
and where the order stayed various actions.
That's right.
And
And
you're saying that
0038, you're telling us, was your aspiration to appeal against the order made between you and Mr. Harangi.
that's correct.
We've got that in your bundle 1 of authorities at number tab 13. And this was one of the judgments, correct me if I'm wrong, of Mr. Justice Domar.
That's right.
That was handed down
Same.
on the same day
That's
as
right.
the judgment under present appeal.
That's right, my lord. There were 3
And
judges.
if we go to the second page
Yes.
of the judge's judgment in the Mr. Harangi litigation, we see in the second full paragraph, I allow the motion of learned counsel for the defendant. The plaintiff did state, that must be you, Mr. Hurnam, he has no intention of retaining the services of an attorney for the purposes of continuing with the case. He has not come up with any motion to show good cause based on exceptional circumstances for the purposes of proceeding without the services of an attorney.
That is correct, because the matter came for hearing, the pleadings were completed, the pleadings were concluded, the matter came for hearing, and there's no need for an attorney on that. This is why.
That's the whole question which we've got
Yes.
to decide. So let's
That's
back to it.
Yes. Once the pleadings are completed, there is authority for the proposition that there's no need for an attorney.
pass it.
And this action is time barred now, if nothing is done about it. As opposed to the present one, where I was never asked whether I wish to retain a service of an attorney. Mr. Justice Doma has mixed issues with that case and the present one, and he handed them out at the same time. Your Lordships, do you follow me?
Can you just clarify one thing to me?
Yes,
You said a moment ago the application was made
on the 30th of,
30th of May.
May 2011.
You say judgment was the 1st of July. That's the full court judgment.
That's full court, yes.
But the judgment in the present case wasn't until February 2014, which is something you're complaining about.
Yes.
So, I mean, if you were going to rely on exceptional circumstances, which the full court judgment allows you to do, you had several years to argue exceptional circumstances.
Yes, but your Lordship would note that my submission in the case of Arangui is that there's no need.
Right. Yes, we've got that.
Because pleadings were all concluded.
Well, all right. That's an argument, therefore, that you're entitled to use a lawyer after pleadings are concluded. Sorry, to try to proceed in person without a lawyer after pleadings are concluded, at any rate, even if you're not before.
It is provided for.
Well, there's nothing which says after pleadings are concluded you can dispense with a lawyer, is there?
Well, the respondents have cited a case from Mr. Justice Balanci of the Court of Appeal, and I've put in the document as well.
Well, show us that case.
Yes, with the judge. I'm not sure whether I have it right. I've been given the copies right now, my lord, so I'm not quite conversant with the matters raised, but they did it only yesterday. I had sent that electronically in the case of Arangui. I can't find it right now. I have it from the...
What's the name of the case?
Sorry, my lord?
What is the name of the case?
It's my name, Hurnam against... the name of the case is my case, Hurnam against the...
The case cited by the respondent.
That's right.
My lords, I think it may be a reference to Hurnam and the state, which is at R17.
Thank you very much.
It's briefly mentioned in a short note that we put in yesterday on the Code de Procédure Civile.
I didn't.
Oh, I'm not sure. I mean, that's on the table here, so I'm not sure we've read it yet.
Lord, yes, I'm not sure that you need to, but as it were, the reason the note went in partly was because there's an interesting discussion in that case as to the residual application of the Code de Procédure Civile in cases of appeals.
Oh, that's quite helpful, potentially. In fact, very helpful. Yeah. Right, R17.
R17.
So this, correct me if I'm wrong, this authority to which you now refer extends the reasoning of the 5 judges from trials to appeals.
Yes.
And in the light of the sad death of Maître Mouet,
At Lucha, yes.
decides that for an appeal, as for a trial, it's not enough that one has an attorney representing one at the outset. There must be an attorney all the way through, subject to the residual discretion. Is that more or less what this case holds?
That was in 2014. Is that correct?
Is that more or less what this case holds?
Yes, but then they come to make a distinction between a matter which is...
We're talking about R17.
Yes.
On the 9th May 2014, which is 3 months after the judgment under present appeal. So what should we collect from this judgment?
Well, my lord, when pleadings are completed, it has been my submissions, they have concluded the pleadings, the need for, the attorney passed away. The matter came for hearing. Once the matter comes for hearing, it was my contention that the plaintiff can proceed in person to the hearing. That was my contention. And if there was anything exceptional about it, please tell me what is exceptional, my lords. Is there any way to define what is exceptional in the rules? No. Nothing is defined. There is no mechanism for defining exceptional, my lords.
Forgive me, you took us to this case because you wanted to find something in it that helped you.
Oh, no.
Oh, you didn't?
No, I didn't say that it would help me, but I said even that case, which was cited by the respondent,
Yes.
comes to say about when pleadings are en état, that they are completed. It is still my submission that once they are completed, there is no need for the attorney.
Right.
In other words, this case was wrongly decided in your submission.
Well, that is, yes, my lord. On
Well,
that
then I
basis,
think we can move on from it.
this basis of ETA.
Yeah.
But in any event, my lords, what we are concerned is what is henceforth. If I may move on to this point, what
Yes.
is henceforth?
Ah, yes,
Yeah.
right.
On a correct interpretation, henceforth can mean, and I understand that, when the law came into force. But in the manner they have set out in this judgment, my lord, if we go back to the judgment of the 5 bench judges, this is the following. We do have noticed that notwithstanding the change in the rules affected by the Supreme Court Rules 2000, actions initiated by litigants have on several occasions been entertained without exceptional circumstances, justifying the exercise of that residual discretion having been established. This is probably the result of an oversight. But in our view, the new regime introduced by the Supreme Court rules should henceforth be applied with due rigor. Having allowed a litigant in person to prosecute in person, and cases have been started before the judgment, it is my submission that the litigant should be allowed to continue.
Now,
Wait a minute.
What
Yes.
happened in the 5-judge case? They said the proceedings were irregular there, didn't they?
They set it aside.
Yes, well, so they didn't apply henceforth to their own proceedings. Why should they apply them to any other proceedings?
No. Well, henceforth, from the date of the judgment.
No, they didn't, because otherwise they would have arrived at the opposite conclusion in the instant case,
Because
in the 5-judge case.
but they would have asked me to give evidence on that. But they did not. Wouldn't your lordship agree to that proposition if they come up with this new proposition, having allowed litigant to carry on?
Yes.
And they come up to say, no, Mr. Hurnam, you cannot go on. You must have special circumstances.
Yes.
Do you have any evidence of special circumstances before we can decide on the fate?
But that's the 5-judge case.
Yes.
You, as I pointed out a moment ago, you had another 2.5 years to produce special circumstances in the present case, which is before us.
Yes, but the case was never called. We asked for postponement to bring the case before to make the proper motion.
Well, you can issue a motion at any point, can't you?
No, My lord, we cannot, no, we can make motion viva voce. Because there is no...
You could have made a motion to the court, couldn't you?
No, my lord, he didn't bring the matter forward. This is the gist of the argument I have.
But a motion, I didn't quite follow you. You received the five-judge judgment.
Yes.
You realised then that there was a problem in the present case.
That's right.
But it hadn't yet been argued, had it, before the judge, let alone decided.
Yes.
So it was open to you. It did come back before the judge, didn't it?
So it did come back, but then I had an attorney retained in the meantime.
Didn't it come back before the judge?
It did, but I was represented by an attorney, my lord. I was represented by an attorney.
You weren't?
Yeah, I was.
Well, you could have made an application if you wanted to appear in person, setting out what the exceptional circumstances were.
Appearing in person, right of audience, Section 12 of the Courts Act does not require any special circumstances.
Yes.
Here, litigation in person, that they say. But at the time when this matter came before the full court, I was duly represented by an attorney who countersigned my motion paper, and
Are you referring to Mr. Mutier, who certified it as a copy?
That's correct, my lord.
That cannot be, the argument against you is that cannot be what the rules contemplate, because signing something as a copy is not a performance of professional duties, it's a performance of purely secretarial or ministerial duties. The lawyer is there for a purpose. He's not just there to act as a sort of a person who can read.
But they didn't decide on that point at all, my lord. The court did not even decide on that. The trial court did not decide that point. I mean, instead,
They did. They said that Mr. Mutier, I think they made a slightly different point, that Mr. Mutier wasn't someone who was going to pursue the proceedings. We can look at the reasoning, but it was to the effect that he wasn't properly really engaged in a professional sense, wasn't it?
Well, no, my lord. This went on undecided by the court. But listen, my whole question is, when I issued process, the judgment of the five-bencher was not out. When the judgment came out, I was asked whether I could retain services of attorney. And I did retain service of attorney. And therefore, the question that arises was for the court to decide whether the retention of the attorney at that point in time cured the defect, and we can proceed all along with the matter. If we could have proceeded by me giving evidence or special circumstances, how could the presence of an attorney to proceed with the matter could not be good, equally good?
Well,
Mr. Hurnam,
can we look at...
whether I could just clarify a few dates, because
yes.
I'm confused. I'm sure it's my fault.
No,
the five-judge judgment was on the 1st
of July
2011.
That's right, my lord.
The hearing in the case under appeal took place on 13 January 2012.
My attorney was alive and he was kicking.
Forgive me. The hearing took place on 13 January 2012.
That is correct, my lord.
The hearing took place 6-7 months after the five-judge judgment.
That is correct.
On page 87 of your record, if you've got that to hand.
Can we just be a bit careful which document we're talking about? 87?
Talking about the record.
The record, yes.
Record, right.
87.
Page 87. This is a transcript of this hearing.
That's right.
On 13 January 2012.
Correct.
And at the bottom, the court is saying, reading the judgment of the five-judge court, no doubt, on several occasions been entertained without exceptional circumstances. So they're interested in exceptional circumstances. And they appear to say to you, is there anywhere we can read the existence for exceptional circumstances? And you don't seem to respond by saying, my lord and my lady, the exceptional circumstances that I rely on, if necessary, are as follows.
My Lord, I wouldn't be able to follow the relevant page, because
I think that
it's 87, is it?
I think that the court's question was
Yes.
asking whether there was anything in the rules where there was a reference to exceptional circumstances. Because the previous submissions have been about the rules, and if you look at your answer,
Yes.
you said no, this has been abolished, and you were referring to Rule 6.
Your Lordship are reading from page 87 of the record, the draft rules. I'm not asking you to decide against a full bench, but this is the purport of the rule. It's totally different.
But wasn't this your opportunity to say, if, contrary to my submissions, I have to show exceptional circumstances, they are as follows?
My Lord, at that point in time, I had an attorney who was appearing in the matter.
He'd not died by this
He had not died by then. They didn't bring forward the matter on a date. He died in August 2012. And the matter was never recalled.
There was still, however, an issue about whether him coming onto the scene late cured any deficiency in your initiation of the action.
When the action was initiated, this judgment was not out. He came into the picture, as your Lordship will note, he came into the picture as your Lordship will see the service 122. No, sorry, it's not 122, my Lord. Sorry, I made a mistake. It's
63, possibly?
62, 63. So he came into the picture immediately after the judgment, the 14th of July 2011. So there was no need for me to come and give evidence of special circumstances. But my Lord Mans is saying that if the 5-bench judges ruled that you couldn't start a case in person, the coming of the attorney does not help you at all. I can understand that. But then how could it help if I were to say to the court, these are my special circumstances?
No, I follow that.
I couldn't follow that. But my Lord is with me on this. Does it cure the defect? If Mr. Mucha wouldn't be able to cure the defect in the process, would any evidence from me regarding special circumstances cure the defect?
If he's coming in and doing this
my Lord,
meant that you were at all material times represented by an attorney,
that's correct.
Then that was fine.
That was, yes.
But there was a query about that. There was a query about whether he could come in late. And so it might have been that you would have said to yourself, well, in case I lose on that point, I really had better explain my exceptional circumstances.
But this is precisely...
I have got exceptional.
If your Lordship will look at page 94 of the brief. The second aspect, it's a court says, is that the applicant in this matter be allowed to give evidence of why he needs to bring facts.
Where are we?
Page 94 of the record, my Lord.
Top or bottom?
At the bottom, right at the bottom.
Okay.
You see, but it starts from page 93 on the top.
Yeah.
On the top. Well, my Lord, yes. It says 93, which party proceeds, unless the 5-bench judge forward makes a competent court to hear and decide on. I would wish to give evidence on that. How they have proceeded in the past, now in the judgment they say this. And then at line 15, my lords, but it is rationalizing the debate in line with the judgment. It says at page 42, we do have noticed that notwithstanding the change the rules affected by the Supreme Court, actions since the litigant had on several occasions been entertained without exceptional circumstances. What? Are they right? Are they rightly? But said, didn't you want to hear me and bring evidence about that? That's what I said to them. And my attorney was still alive. And I go on to page 94 at the bottom, the second aspect, the court says. So the 4 points raised as follows. The judgment of the full bench talks about henceforth, and this case was started before. The second aspect is that the applicant in this matter be allowed to give evidence of why he needs to bring facts, that such discretion of the court be exercised in his favor to continue with this case.
I think the most helpful bit from your point of view, Mr. Hurnam, is if we go on to page 99.
99.
Which is the submissions against you of Mrs. Poon.
Yes.
The foot of the page.
Yes.
The rule now is, line 25, the rule now is that all proceedings should be entered and initiated by an attorney, which hasn't been the case.
That is correct.
We cannot now have Mr. Moutier be allowed to appear, and what is his involvement now in the present case is to certify. From the Oxford Dictionary, meaning of certify means confirming the motion, confirming as to what?
Yes.
I will suspect that it is only confirming as the applicant having signed the motion paper,
Yes.
and as the applicant having signed the certificate, and she was only too right about that. And then she goes on, therefore the request made by the applicant to have him heard on the evidence as regards the exceptional circumstances that he should be allowed to proceed are not applicable in the present case because he wishes to have to be represented by an attorney. So she's trying to answer your request that way. And then further down the page, you say, well, I think the respondents have misunderstood you. My motion and my submissions are being made on two folds. First, the matter is to continue, and for me to give evidence without any prejudice to the matter pending before the Privy Council and this issue of the attorney. This is my first. This is what I say if the court, which intervenes.
That's right.
And the court says we're very clear. And then you go on. I don't think she's understood my point. This is what I said. Without any prejudice, I'm saying that whether I could proceed with my motion paper signed by me, affidavit and all, can I proceed on that? But before I do, can the court hear me on the exceptional circumstances?
Precisely.
And the court then adjourns to give judgment, and you say that that's in the air, and they never really...
Yes.
They should have given you a chance. But, I mean, the fact remains that you didn't identify what the circumstances were, and you still haven't done so.
No, I couldn't do it because I was not given an opportunity to do that.
You've had years since then to say to us, an injustice has happened because these were the exceptional circumstances. I mean, what are they? What were they? We've got no evidence at all.
My Lord, I have said that in the beginning of the proceedings somewhere that no attorney wishes to sign proceedings against judges in the court. This is said so in the course of my remarks. Your Lordship.
There may be rather good reason for that. I mean, maybe they feel on evaluating your potential claims that they can't professionally support them. So you've got to go a bit further than just say no attorney will act.
No attorney, because
that may be precisely why an attorney is required to act as a safeguard against vexatious claims.
No, my Lord, this is not a vexatious claim. But they wouldn't go.
Maybe you've got to actually go a bit further than just to say no attorney will act.
Well, I had given reason on those lines, and I was to say, give me a chance to give evidence on that, because you would see from the nature of the application, they are against the judges of the Supreme Court. Disciplinary proceedings, reopening of them, is the judges, the Attorney General, and therefore they wouldn't go. They are officers of the court. They appear before the court. They wouldn't go against the judges. This is sort of a...
I mean, we mustn't get into the merits of the case, but just yes or no, Mr. Hurnam, is there any system of judicial immunity in Mauritius?
Well, judicial immunities is for the state liability only.
All right. Well,
the judges are not amenable to proceedings for acts done in the course of their duties.
Yes.
But you can't sue judges for getting it wrong.
But
you do other things if they get it wrong. You appeal.
No, my Lord, no. But we have a special provision which is set out in the law in Mauritius regarding magistrates and even judges.
I see.
Where's that?
Protection of...
Anyway, the point is you say that it's difficult to get attorneys to certify the kind of action that you want to bring. Now, what you need to understand is that it may be that, in fact, it is suggested that the reason why the requirement that actions be begun by attorneys is so that they put their professional judgment behind the action.
I totally agree with that reasoning,
Okay.
but the fact of the matter remains, my lord, that judges in our jurisdiction are amenable to civil claims. They're not, so long as the conduct of them in court. There is a special legislation which does apply to judges as well, and they have pronounced it on this matter.
Okay.
If your lordship will look at the
That's all we know. That's enough.
Public Officer Protection Act,
Thank you.
which is part of the bundle which I have submitted to your lordships in the case of reopening of the disciplinary committee. The Public Officer Protection Act has been attached somewhere, my lords.
On this point,
Yes.
assuming it's open to you in these proceedings, what are you seeking? You're seeking simply an opportunity to demonstrate exceptional circumstances before the local courts, because we can't decide it. We're not going to hear evidence from you.
That is why I did not put in an affidavit, my lord.
No.
I did not put that.
Well, there might have been a different reason for putting in an affidavit, namely to persuade us that there was something in the point. But assuming we were to think that there was anything in the point, what you would be having to submit is that you should have, even now, an opportunity to demonstrate exceptional circumstances. That's all you could submit, isn't it?
But I would simply suggest that this board directs a remittal and invites the court to consider special circumstances, if at all, in all the matters, except for one where there was an attorney and was shut out from addressing the court altogether. There was an attorney, and I couldn't do that.
When the court gave judgment, did you say to the court, you haven't dealt with something, you haven't dealt with my request to give evidence about exceptional circumstances?
No, my lord, the judgment was filed in the registry. We are sent letters subsequently. This is brought out in the record.
No, but after you saw the judgment, you could have raised points, couldn't you?
He's gone already. He's retired already on the 24th of February, 2012. Sorry, 14. So the court was not...
He retired when?
In February 2014, immediately after the judgment.
Okay.
So your lordship will note from the record itself.
Clearing his desk then after 2 years.
Yes, my lord. It's, if your lordship will kindly bear with me about the judgment was on the 24th.
Yep.
Page 117 of the record, my lord. You see, the registry, I'm directed to inform you that ruling in the above matter has been filed today. So it's by post. Your lordships have page 117, 118 of the record. So, and he's gone by then.
He's gone.
He's gone. He's retired already.
How can he retire? Well, he can give judgment after retiring, can he?
No, before retirement.
Oh, yes, I see. So he retires straight away, does he?
Yes, he retired straight away. Yes, I've heard that in my
Right.
argument. And even for the other two cases, 119, you can see all the judgments are set out there. The rulings have been filed. And I received it on the 26th of February, my lord. You would see that at page 121.
He gave a whole lot of judgments on...
3 judgments. And there was a mix-up, I suppose. 3 judgments, my lord.
I see.
Your lordship has seen at page 121, the date I received the notification, 26th of February 2014. By that time, he has retired. So even after judgment was handed down, I could not do anything at all.
Yeah. Right.
Basically, Mr. Hurnam,
Yes, my lords.
the question for us is whether the analysis of the law in the 5-judge court is correct. You produced a long skeleton argument. In that skeleton argument, did you say, I was never given the opportunity to explain what my exceptional circumstances were?
No. On the day they handed out the judgment, my lord, the 1st of July, I said, would you stay the judgment? I gave particulars of that exceptional circumstances, whatever you wanted me to give. That was reopening of a conviction.
Mr. Hurnam, I didn't make myself clear.
No.
I apologise.
No,
In your skeleton argument for us today,
no, I did not make that.
have you said,
Not in the-
I was not given the opportunity
No, my lord, no.
to explain my exceptional circumstances?
Once they handed out the judgment, no, I have not explained that in my skeleton argument, but on the day they handed out, I was present physically, and I asked them to say whether I can give evidence of the special circumstance before you set aside the application.
But this was 1st of July.
1st of July.
Well, that's a different case. We're not hearing the appeal in that.
But this is, no, that's a different case on which, yes. That was the main judgment which we...
You say, what did they say on the 1st of July?
1st of July.
They just brushed it aside?
Yes, it just brushed it. No, it's over. The case is over. But you would expect, my lord, that it's a new point they have taken for the first time, had allowed me on previous occasions to carry on, and suddenly say, no, how can I disclose special circumstances in application when there was no such direction or order from the court prior to that application? We're in the same position as this one.
Right. Now, we're getting near the maximum time you indented for, which was 2 hours, and so I think you ought to try and conclude your submissions.
Would your lordships consider that in my reply, that would be okay, just in case I have missed any point? I've been given a lot of documents just now, this morning only.
Yes.
In reply, I would conclude, if your lordship have no objection, because there are lots of other matters about this very judgment of the court. The court, in handing out 3 judgments, got mixed up, either sitting alone or sitting together with Mrs. Justice Tilak. They never even read the record, I have said.
Why does this matter on the...
It matters because he has Mr. Doma sitting together, Mr. Justice Doma sitting together with Mrs. Justice Tilak, imports from his own personal judgment, matters.
We're dealing with an issue, a single issue, about whether you should have been allowed to appear in person.
Yes.
Can we stick with that?
Well, your lordships have seen Section 12 of the Courts Act, but this is reproduced in the judgment of the, sorry, my lord, the landmark judgment of this board, myself against Paration. Can I just get that out first, if your lordship will allow me 2 minutes? I made a note of this. Page, although I will have the difficulty of the pages, I don't know why these have not been set down, my lord. It's, if I may just rush through, Paration is tab 17.
In your what?
In my brief, tab 17, my lords.
In your skeleton.
Bundle.
In which bundle? In your bundle of
Authorities.
Volume 1 or Volume 2?
It's volume 1, my lord.
Thank you.
Yes, it's volume 1. Sorry.
The Paratian case.
Exact, my lord. Your lordship has seen that already. Can I see that? Volumes. It seems. Yes, my lord. Well, electronic page is 362, 363. This board has had the occasion to answer that. The right of a litigant to appear in person is at page 12 of the judgment. If in it
page
should,
12.
Page sorry, paragraph. Sorry, it's paragraph. Page 5 of the judgment. That's not page 12. Section 12. Your Lordship has the page.
No.
No, the judgment.
Yes.
Page 5.
Yes.
The Court Act provides. Section 12, right of audience.
Right.
There should be in any proceedings before the Supreme Court, any of the following persons may address the court. Any party to the proceedings with leave of the court, a barrister. And then then the Rule 60 was applicable, my lord. And the board had this to say, and this reminds me of the following. This again suggests the judge may have been under some misapprehension as to the scope and effect of Section 12 of the Courts Act. But it is unnecessary to inquire too closely into the judge's reasoning, since Section 12 on its face clearly confers a discretion. But a discretion which, in their lordship's opinion, the judge was bound to exercise in such a way as to secure the defendant a fair trial in accordance with the overriding requirements of Section 10(8) of the Constitution. A trial in which one party has the opportunity to address the court on the facts and the law, and the other party is denied that opportunity, cannot be a fair trial. It makes no difference whether one or other or both parties are litigants in person. So the right for a litigant to appear in person has been settled.
Because that was a case in which the defendant, you, had not been able to address the court and your opponent had. Is that right?
My lord, I was defendant. I was
Yes, quite.
Precisely.
Yes.
Precisely. And you had not been allowed to address the court,
Yes.
but your opponent, the claimant, had.
Yes.
And that's what this board said was wrong.
Yes.
Got it.
That's correct, my lord. But I'm answering the question to your lordship here, that on the issue of whether I've got right to address. But then the right to address, how would you reconcile Section 12 with Rule 3 of the Supreme Court rules, my lord? If a party has a right, a party in any proceedings may address with leave of the court, doesn't this run with a party who can issue process in the court? Is it not a corollary to that, my lords?
Yeah, okay.
Or it runs counter the argument of the five-bench judge, that I must have leave to initiate proceedings and I must have leave to appear in person. They go together, hand in hand. So once you enter your proceedings, and then you appear in person with leave of the court. And Section 12 overrides Section 3.3, Rule 3.3. And my lords, the question about, your lordships earlier asked about the question about whether an attorney will see whether a case is justifiably stands success in court or not. There's a point to be given. But listen, what would you lordships have seen at page 7 of the judgment, when the court has attached terms to my address, this would be at page 7, because the court has inherent jurisdiction to stop any proceedings at any time if there is some sort of abuse. Nor would such a reason be considered with allowing the defendant to cross-examine the plaintiff and his witness. If there was a risk of the proceedings becoming acrimonious or some other abuse of the court's process, it would surely have been occurred during the defendant's lengthy cross-examination of the plaintiff. A cross-examination which started on 21st February 1995 and continued throughout the whole of 22nd February 1995, yet the cross-examination appears to have been conducted with propriety. The court never found it necessary to restrain or rebuke the defendant at any stage. So if a cause of action is entered by a litigant in person, and if there was something abusive about it, the court still has discretion to stop that, if at all. But when I read Section 12 of the Courts Act and the Rule 3, well, they must work hand in hand, my lord. What is the point of 12 then? There's no exceptional circumstances. Simply viva voce, come before the court and say, can I appear with leave of the court? would your lordship wish me to address on the matter as set out in my skeleton arguments towards the end, at page 27 of my skeleton argument, line 5. Your lordship would follow me, please.
27, line 5, right?
Appellate's apprehension is such that the retired Judge Doma, who was senior to Judge Tilak, may have adopted the same method as SPJ Matadin adopted with
I think,
Yes.
what has this got to do with the point which is in front of us?
Well, your lordship will see that about the question asked earlier on, whether there's a mix-up with the three judgments.
It doesn't matter, does it? I mean, we are dealing with a judgment and the effect of it, and we know that the judgment refused you the right to pursue proceedings in person. The only further point I've got on the question of exceptional circumstances, is there anything you want to draw our attention to in the notice of appeal which covers the point that you, the complaint you made about that before us?
I think you've accepted that it doesn't feature. It didn't feature in your case.
It's not in the notice of appeal either.
The issue of exceptional circumstances. It is, my lord, at page 27.
Sorry, page 27.
Line 25, 24.
Of what? Oh, of the...
My skeleton arguments.
I see, right.
But in any event, even the court never directed itself the averments of exceptional circumstances to be set out in claims issued prior to the interlocutory judgment of 1st July. That is why the court had due to invite evidence of exceptional circumstances, if any, before setting aside the claims.
Yes, I see.
That's a different case, though, isn't it?
No, it's the same case, my lord. Well, I set out the...
Which case are we talking about there?
No, it's the same one. These were not cited in the present appeal, and there is a perception that former Judge Doma may have returned to Doma without prior consultation, and this remains my apprehension. But in any event, the court never...
You're dealing...
Yes.
In claim, I see, in claims issued prior to the interlocutory. Yes.
It is set out, if any.
Yeah.
And I said about the...
Yes, I see. So you raised the point there.
Such a conduct cannot be exercised, but yes.
Yeah.
Well, I
Yeah. Right, well, now, I think your time has now expired, but you've already said, I think, that any other points, if we get to a reply, would be raised then.
Please. Yes.
Right. Yes, Mr. Casey.
My Lords, on the question of exceptional circumstances, can I just pick up on a small chapter immediately after the argument in January 2012, which may be relevant?
Right. Very helpful.
And my Lords, I think one finds it at one picks it up at page 102 of the record.
Yes.
So, my Lords, this is a little over a month after the substantive argument in the present case. One sees that...
to make a motion.
Yes, so Mr. Hurnam had written to the court on the 14th of February.
Can we look at that letter?
My Lord, I don't think we have that, but what we do have at page 103, I think gives us an indication as to what must have been in that letter.
Yes.
So you made a motion very shortly after the hearing, but it wasn't anything to do with exceptional circumstances, it was to do with interim relief on the merits.
Yes.
Okay.
Yes. Right.
So one might say that and I think this echoes one of my Lord Mance's points, that when one sees the passage at the very close of the argument at page 100, where one sees the appellant saying, I'm saying whether I could first proceed with my motion paper signed by me, affidavit and all, can I proceed on that? But before I do proceed, can the court hear me on the exceptional circumstances? One doesn't see, at least at that stage, him being told, no, we won't hear you on exceptional circumstances.
I'm just wondering about that passage on page 100. I confess that I'd read it as, in effect, there's no question of exceptional circumstances, because he goes on to say, I cannot invoke a spent rule to come before, in other words, Rule 60.
Yes.
I cannot invoke a spent rule to come before the court and say, give me leave. How would I come before the court and ask to leave? Is he there asking the court to hear him on the topic, or is he saying that there is simply no...
Yes, he's standing on his submission.
Yes.
If one reads the rest.
Well, my lords, I think that may well be right. And/or he is essentially going on to say, to make his case on exceptional circumstances, so far as he has to, which is when he repeats his point at the bottom of the page. I can only come to the court by a substantive motion and explain why I could not retain the services of attorney. No attorney wishes to sign this document for reasons I explained.
Yes.
That, it may be that is him making the case that he wishes to make on exceptional circumstances.
But he says, it is impensable today that I must pre-innate, I suppose he means revive, Rule 60.
Yes.
So, yes.
My lords, it seems to me that either he's saying, my position is one of principle, that as it were, there's no room for me to try and invoke some exceptional circumstances. That's one of the problems with the whole case against me, that now that Rule 60 has gone, there's no room for that. And he's taking a stance of principle, saying that on that basis I make no such case. Or possibly he's saying, so far as I have to, these are my exceptional circumstances. No attorney wishes to sign the document.
What about the next paragraph, which is pretty obscure too? The last observation is the certification by Mr. Moutier of the affidavit and a motion, a notice of motion. As I said, first allow me here evidence on whatever circumstances. If the court says no, then the next issue, as an alternative measure without any prejudice to my earlier motion, let us see whether Mr. Moutier's intervention has cures the defect. So on one view, he's there putting it the other way around, and saying, let's first hear evidence about exceptional circumstances, if that's what he means by whatever circumstances, and then if the court says there are none, then the next issue is, let's see whether Mr. Moutier's intervention has cured the defect. Is that what he's saying? Perhaps it is.
My lord, perhaps. My lord...
Anyway, yes.
Our position is that by the time this hearing occurred, as one had added, that the relevant chronology had been, I think, argument in the full bench case took place in February 2012. And so that's when the full bench, one knows that the decision came out in July 2012. From Lord, I think one sees from the judgment itself.
2011.
Sorry, 2011. Sorry, yes, 2011, my lord. So argument in the full bench hearing, February 2011. These proceedings issued late May 2011. So after that argument, so at least after the appellant knows this is now a very much a live issue in relation to his cases which he issues in person. Then the full bench decision in July, 1st of July 2011. And my lords, there was then a hearing in this case on the 20th of July 2011 to consider where now that leaves this case. Because the matter had cropped up back in June, and the matter had been stood over pending the decision of the full bench. And Mrs. Justice T-Lock essentially invited the appellant to consider then getting an attorney in to regularise matters.
So you then got this rubber stamp at the bottom.
Yes. from Maitre Moutier. And my lords, I'll make my submissions on that briefly in a moment, but we submit that essentially, for the reasons already explored, that couldn't meet the requirements of Rule 3.3 if we're right that Rule 3.3 means what we say. But just in relation to then the question of exceptional circumstances, I'll come in a moment to how those might arise juridically, quite where this discretion or possible discretion comes from. By the time one gets to January 2012, we submit, it was incumbent on the appellant, if he wished now to make submissions to the court under that part of the judgment of the full bench, to come with his material. One doesn't see from the transcript on the 13th of January 2012, at least, that, if I can put it this way, that on that day, the court shut him out from addressing exceptional circumstances. And on one reading of the transcript, he did so, but in very brief terms, namely, no attorney will sign this document. It wasn't not clear to me on reading the transcript whether he's saying he'd asked attorneys to adopt the document and they'd refused, or whether he's simply saying it's quite clear they just never would. But he wasn't shut out on the day from adducing evidence, if he so chose, on the point. And when he returned to court shortly afterwards to make a motion, he made a different motion. My lords, I don't think I need to trouble you with the detail, but he was trying to obtain a ruling that, as it were, he have interim relief pending the final judgment. Right. And he was pointing to what he said was a comparable case involving a doctor. But in my submission, the point then can fairly be made that at that stage, or some similar stage prior to the handing down of judgment in the case, he could have made a similar motion, but invoking the court's power to consider whether he should be excused compliance with Rule 3.3. But he didn't. And then, as we've pointed out in our case, in his case to the Privy Council, he hasn't really explained what he would have said about this had he taken the opportunity to say something about it. My lords, before briefly moving on to consider the provisions of the rules themselves and what we say are the central questions for this hearing in terms of what the rules say and how they should be interpreted, can I just pick up on one other matter that may have caused some confusion, which is Section 12 of the Courts Act. We've handed up this morning, so I'm afraid it's loose, the first sections of the Courts Act, which deal with the Supreme Court. My lord, yes. I'm afraid it's not paginated. So section 12 is a few pages in after the relatively long index at the front.
Underneath that loose leaf folder. Yeah. 12. Yeah.
So section 12, one sees, deals with rights of audience and deals with the persons who may address the court, including any party to the proceedings with leave of the court, and then otherwise a barrister or an attorney in bankruptcy. And of course, one sees in this case that, that the appellant was repeatedly given leave to address the court on the arguments that we're now dealing with. But that, of course, is a different question to whether the non-compliance with Rule 3.3, if there was one at the outset, meant that the proceedings were defective and at risk of being set aside. And my lords, while we're on that page, it may also be relevant to note sections 15 to 17, which deal with the jurisdiction of the Supreme Court and its powers.
What, preserving, you say, inherent control of its procedure?
Precisely, my lord, yes.
Yeah. So that 12, you say, covers the position generally.
Yes.
Insofar as it's not clear from the rules. It's
Yes.
a matter of discretion for the court.
Absolutely, but that's 12 is dealing on the face of it simply with rights of audience at hearings.
Yeah. Yeah. Yeah.
Where's the power to make rules?
My lord, that's section 198, which we haven't reproduced here, but my lord has in R8. So if my lord has R8, that's the Judicial and Legal Provisions Act 2000.
It's added or it's amended, yes.
That's right, my lord, yes. So section 2 deals with various amendments to the Courts Act, including one sees at MS page 441, subsection E, deleting the old section 198 and replacing it with the following.
Yeah.
So that's the power to make rules. And then 1982, the following enactments shall be deemed to have been made by the Chief Justice under section 1981, Supreme Court Rules 2000.
Right.
But as my Lord Hughes points out, we say that it's clear then that the Supreme Court has the same, essentially, the inherent jurisdiction that the courts in England and Wales have to control their own procedure. And it's in our submission, that's where one gets to if there is established a failure to comply with Rule 3.3. And so what the full bench refers to as the residual discretion to deal with the case appropriately on the facts, essentially we submit reduces to that question. If there is established a non-compliance with a mandatory rule.
Yeah, that's the point which,
Yes.
you've made in your case.
My Lord, yes. So, my Lords, can I go briefly then to how we say the rules are properly to be read in relation to these issues? And hopefully, my Lords have got I think the entirety of the Supreme Court Rules 2000 at R2, starting at MS 389.
Can I just ask, sort of jumping back?
Yes.
Do we have the transcript of the argument before the full court, which led to its judgment of the 1st of July?
My Lord, we don't. Not in the record.
Because they did deal with the question of exceptional circumstances, and the present judgment effectively simply follows the full court on the point, although it also adds that in the present court's view, Mr. Hurnam had not done more than stand on his submission that he could appear in person. Now, the present court may or may not have been right on that point, but it certainly followed the previous court's view about no exceptional circumstances. So it might have been quite interesting to see what was said to the previous court about exceptional circumstances.
My Lord, I agree. I'm afraid we don't have that.
Yeah, we don't. Right, thank you. Sorry, now we'll take you back to where you were.
My Lord, yes, I was going to go briefly to the rules themselves.
Yes.
So R2. And my Lord's taken through firstly some preliminary points. Rule 2.1, except as otherwise provided for under any enactment and subject to paragraph 2, civil and commercial proceedings before the Supreme Court in its original jurisdiction to be initiated by plaint with summons. And then Rule 2.2 sets out some cases where an action may be initiated by way of motion supported by affidavit, and that, as a matter of fact, is what was done in the present case. Rule 2.5, though, states that, subject to paragraph B, no objection shall be allowed on the ground that the wrong procedure has been adopted for initiating any process. And 5B gives the master or the court power to direct that pleadings be redrafted for the purpose of complying with the correct procedure. And then 3, contents of plaint with summons. And so 3.1, one sees the requirements there as to what the document must contain. 3.2, I presume, has been deleted, but 3.3 is the crucial one. Every plaint with summons to be endorsed with the full name, office address, and stamp of the plaintiff's attorney, which shall be the elected domicile of the plaintiff. So,
Mr. Hurnam said that that provision was in the previous rules. Do you know whether that's right?
well, if my Lord turns to R4, we have reproduced what seem to us to be the relevant provisions of the previous rules, and I think it's Rule 15 of the previous rules, which is MS 403, is the closest one gets.
Yes. So you had the rule requiring it to be in the name of the attorney, i.e. there should be an attorney, but you then had Rule 60, which gave a special power to apply in person.
Yes.
And so what's happened is we've lost Rule 60 and we're back to the basic rule.
Yes, we've lost Rule 60, and also Rule 3 applies to plaints with summons, so if you like, originating process, originating...
Yes, there's the issue of whether that applies to motions as well.
Yes.
And Rule 15 obviously applies to both claimants and defendants.
Yes, all pleadings.
Whereas Rule 3.3 of the new rules only applies to claimants,
Yes.
plaintiffs. Yeah.
Yes. And my Lord's Rule 3 then continues with Rule 4, requiring the plaintiffs to specify the purpose of the appearance of the defendant, and that a failure may result in judgment against, a failure to appear may result in judgment against him. Then, my Lords, we've drawn attention, although it's not referred to by the courts below, also to Rule 5, dealing with methods of service.
Yes, which clearly involve an attorney acting for the claimant.
That's right, my Lord. In particular, 5.2, any process shall be drawn up and signed by the party's attorney and served in accordance with Para 1, so by registered post or by usher.
And Rule 5.3 really deals with defendants. When it says where a party is represented, it must mean where the defendant.
I think it must, my Lord, yes, because it goes on to deal with service of the process in the action and in all related matters.
And then Rule 5.4, again, any answer made by a defendant may be addressed in writing to the attorney who's caused the process to be issued. Yeah.
Yes. And then, my Lords, also relevantly, Rule 6, 6.1, if the summons or other document is to be effected, I think if service, it must be, if the summons or other document is to be effected in accordance with 5.1a, service by post, it should be posted in an envelope on which there's a notice that if undelivered, to be returned to the attorney, whose name shall appear on the envelope. And then 6.2, the attorney shall file in the registry the declaration they're referred to. And 6.3 again, if the document's returned undelivered, the attorney shall proceed with service by an usher. So again, on the face of it, requiring A, the instruction of an attorney, and B, that the attorney do certain things. Then, my lords, if one moves to part 2, dealing with pleadings, one sees under Rule 10 that the defendant or any other party may apply for particulars of the plaint. And then 11 deals with what we would know as the defence, here referred to as the plea. So once all particulars have been filed and documents communicated in accordance with Rule 10, the defendant or other party is to file his plea. And it moves on to deal with the requirements in relation to the plea and any counterclaim, if any. And there, and also in Rule 13, one doesn't see a similar requirement now imposed on defendants to include in the plea the name and so on of an attorney.
Right.
And my lords, it may also be relevant to note Rule 15, in particular Rule 15.3. Court may, after hearing any interested party, order an action to be stayed or dismissed, etc., where the plaint is, and then B, an abuse of the process of the court. Now, my lords, Rule 3.3, of course, applies on the face of it to plaints with summons. But it's our submission that when one moves on to Rule 22, one finds the provision, again, not expressly adverted to by the courts below, but one finds the provision that makes it clear that that requirement there expressed in relation to plaints with summons applies to originating process of all types.
Why is that put in under the heading case in shape?
Well, my lord, it wasn't clear to us why it's there and why it's not earlier.
Well, quite.
And whether one might have argued on behalf of Mr. Hurnam that, as we're finding it there, means that these rules, when used in Rule 22, simply means the rules are under this part, under the part of case in shape. But in our submission, that wouldn't be a correct reading. Firstly, it doesn't then very easily fit with what one finds in Rules 23 and 24.
Well, there isn't a reference to the plaintiff or defendant expressly in 23 or 24.
There isn't, my lord, no.
So,
And in 23, there's a reference to 23.1, there's a reference to pleadings, cases with pleadings, and then 23.2, there's a reference to cases with affidavits, which one might have thought wouldn't be necessary if 22 was designed simply to be read into 23. And 24, I think, doesn't contain any of the relevant phrases which have been referred to in Rule 22. So, my lord, although I see that finding it there may make one question whether it is intended to refer back to all of the requirements of these rules, in my submission that's the right way to read it. For what it's worth, the expression "these rules" may be picking up on what one sees right back in Rule 1.
yes?
Simply says that these rules
Yeah.
may be cited as the Supreme Court Rules 2000. And, my lords, we've also referred to a decision of the board in a case called Piganiol and Smeg, which my lords will have at R12. This case in which my Lord Wilson gave the judgment dealt with a rather bewildering sequence of proceedings which were commenced, not responded to, resulting in a judgment which was then, as well, there was then a separate set of proceedings to rescind that judgment and so on. And without getting down into the detail of those facts, which are not comparable to these facts, if I can simply pick it up at paragraph 10.
You say you referred to it. Where have you referred to this in your case?
My Lord, sorry, my Lord, give me a moment. It'll be shortly after the reference to Rule 22. Para 28, internal page 10.
Okay. Thank you. Yes, that's very helpful. Right, so which bit are we looking at in it?
Paragraph 10.
Paragraph 10, right.
I mean, it was on an entirely different point, wasn't it? An affidavit was required to support a motion. Who should swear the affidavit?
Yes.
But you rely on the fact that the board does seem to have taken Rule 22 as being generally applicable to the rules.
Precisely, my Lord, yes. And that's really made clear that, as my Lord says, the argument in that case was, although one doesn't find this in the rules expressly, it was submitted that the affidavit, where one has motion supported by affidavit, must be from the relevant party or his proxy.
Yes.
Here it was from a witness. And
the board said that was okay.
the board said, in fact, that was okay. And at para 16, that in answering the question, some assistance is derived from Rule 22, and then there's a citation from that. And then referring back to Part 2 of the rules entitled Pleadings, providing that in a case of a plaintiff with summons, etc., these are the pleadings. And then...
Wait, this is probably binding authority on its point, isn't it? If some assistance in the decision was based on it.
My Lord, yes. And then right at the foot of that page, Rule 3.1 governs the content of the plaintiff with summons and provides that the plaintiff with summons must comply with those particular requirements.
Yes.
Not our attorney requirement in that case. The content of the plaint is therefore prescribed by A and B, and the summons by C, and the accompanying notice by D. Rule 13.1 governs the content of each of the three species of pleading and provides every pleading shall clearly and distinctly state, etc. Follows, therefore, that in the case of the initiation of an action by motion, the supporting affidavit must state, and then going back to those requirements, prima facie imposed in relation to plaints.
Yeah.
Right. Well, would that be a convenient moment?
Lord, yes.
I look forward to hearing you further at 2 o'clock.
Are you going to give the amici curiae a little time or some time to make any observations supplemental that they want?
Absolutely, my Lord,
You've
yes.
had a word with them?
Yes.
Good.